Hello everyone, this is Tom Fox. Welcome to the FCPA Compliance and Ethics Report with a special UK edition. I'm pleased to have my colleague from across the pond, one of the two BriberyAct.com guys, Barry Vitou, who's going to visit with us today. He wrote a series of, or he and his partner Richard Kovaleski, QC. For those of you who don't know, that means Queen's Counsel, so we always have to say QC when we talk about Richard Kovaleski, QC,
Very cool.
as opposed to Barry Vitou or Thomas Fox, Esquire. Nevertheless, Barry and Richard have put up a series of posts over the past several days about some new developments and insights into the Bribery Act. And I wrote about those today, citing to the post, but I had the opportunity to visit with Barry. So this episode will really detail some of the things that are going on across the pond. So with that, Barry, it was clear from some of these posts that there had been a regulatory conference at Pinsent Masons, your law firm. So could you tell us about that, who attended, and then begin to share some of the insights you gained there?
Yeah, we had, the idea was dreamt up a year ago. We decided we would put on the regulatory conference of the year, and interestingly, we thought there's a lot of regulatory sort of enforcement, criminal lawyers within the firm doing all sorts of different stuff, not just the esoteric, sort of exotic, economic fraud, international bribery type stuff that perhaps you'd be familiar with in the US, but everything. For those viewers who are familiar with the UK, we've had a big scandal about horse meat recently, and we've got some people in the firm that are dealing with that, acting for big retailers, helping them out. So the idea was to sort of showcase that, and as part of that, I thought it would be a good idea, we thought it would be a good idea, if that we make the conference targeted for the attendees. So that means that we got some regulators in, and the basic plan was to have some slots for the regulators, another slot in a keynote panel session for the regulated, where rather than having Pinsent Masons lawyers stand at the front boring people to tears with PowerPoint slide decks, which by the way I don't do, but to make sure that didn't happen, that we would have panels of regulators. We would have a Q&A, in this case with David Green, which I did. We would then do panels with the regulator, with some CCOs from some top companies. So, for example, we had a compliance officer, senior compliance officer in from Ernst & Young, who works for the global sort of operation that sits above all the EY member firms, and I don't know how many countries there are in the world, but they're basically in all of them. And so if you want to talk to somebody who has to deal with global compliance issues, then that's a good person to have on your panel. We had some others in from former ING Bank, CCO, they've had their issues in the past, and somebody else in from RBS. Now, of course, they have had very few issues, for those of you familiar. So and basically talking about the sort of the practical challenges which they face. And then in the afternoon, we did some breakout sessions. And the session that I ran was about PR in a crisis, because I like a good crisis. And we had a friend of mine in who was a former assistant city editor for the Daily Telegraph, for those of you who are familiar with that newspaper. And we did a little case study, which was starts off with some fake documents, good fake documents in this case, some emails and letters from a potential whistleblower, which, if you got them, would be what we call here a day-changing moment. Anyhow, it was a great day. And I have posted about some of it. There is more to come over the course of the next couple of weeks or so. You will have seen that at the weekend I posted quite extensively on the David Green speech, which is published, and have got some coverage. But there was also a Q&A session which followed that speech, and there are a few more tidbits that I'm going to. I'm not going to tell you what they are, but I'm going to be writing about them in the days to come. So that was it. It was a great day, fantastic feedback, and we're going to do it again.
Well, at the end of our podcast today, perhaps we can get some teasers on those tidbits. But one of the things I wanted to ask you about, you wrote in a post entitled SFO to Target UK PLC in Corporate Crackdown, It's Still All About the Money. One of the differences between basic UK corporate law and US corporate law in terms of corporate intent and respondeat superior. Could you explain that to us?
Yeah, well, I mean, you could probably best explain respondeat superior, but basically, in the US, as I understand it, there is a broad concept where the conduct of an employee can be attributed to the employer. Is that right, Tom?
That's correct.
Right. And in the UK, we just don't have that. The closest it's ever come, and why there was such a hullabaloo over the Section 7 failure to prevent bribery offence, is that it is very, 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 very difficult to prosecute a corporate in the UK. Because we have, broadly speaking, what we call the directing mind principle, which, to put simply, means you've got to have evidence which pretty much nails the main board as knowing what's going on. And David Green has, somewhat cynically, with a wry smile on his face, made the point that in most cases the email chain dries up some layers before it gets to the main board, which is his way of saying it's very difficult to prove it.
But I thought the point of Section 7 was to do away with that required step and
That's
allow.
Yeah, and you're right. And Section 7 was to get rid of that in the context of bribery for the failure to prevent offence. The old rules still apply in relation to bribing, receiving a bribe, and bribing a foreign public official. So all that old stuff is still relevant. But the point that he's getting at is that, for example, if you were to pick general fraud offences, you've still got this issue. So he's very keen for the Section 7 offence to be extended beyond pure bribery and to more generic fraud offences. So that's what he was talking about.
Would that entail a change to UK law?
Yes.
And could you speculate as to the likelihood of such a dramatic change?
Yeah, well, I kind of got to say I think it's likely, but I think it's a slow burn. I think that there's going to be, he's agitating for it. I know that within government there are those that are for it, and I know that there are also those that are against it. And there will be, I think, a significant lobby of Bribery Act-esque proportions along the lines of this is terrible. Catastrophic. The world will stop turning. You think of the worst scenario you could ever possibly think about. That's what will be portrayed as happening. The world will end if we bring this in the UK. And I suppose I've got very simple sort of thoughts about that, which is one, you guys have got it in the US, and so far as the last time I went over there, which wasn't that long ago, everybody was happily carrying on in the same old way, and you've had it for years. And second, I think there is, at the moment, there is a public demand for it. And politicians are ultimately very keen to get in the good books of voters. And I sort of think, on balance, it's pretty hard to argue that a legal technicality which prevents corporates from being prosecuted in what many would say, in cases where many would say, well, they should be, and why is hard to argue. And frankly, we've already crossed the Rubicon because the Bribery Act failure to prevent bribery is already in, and that is just a subset of fraud.
Right, right. Now let me turn to some other remarks by Director Green, which generally involve self-reporting. And I know that's been a topic of a lively debate, both with yourself and others in the Bribery Act community, and indeed I think with the current and former director of the SFO. But could you talk about what Director Green had to say? And then I think it's a very nuanced position that he's taken. And then I would ask you, how might we as practitioners explain that to our clients so that they understand the benefits, if any?
Yeah. There are, well, I think that his position, nuanced as it is, I think is pretty straightforward. I mean, he is a prosecutor. He's going to apply the time-honoured tests here for weighing up whether or not to prosecute. One of those tests is whether it's in the public interest. And he has said, if you do a genuine self-report, which means you tell us something we don't already know, we wouldn't have found out, you remediate, all that sort of stuff. If you do a genuine one, then when I'm weighing up the public interest test, that fact will weigh very, very heavily in my book in determining whether or not to prosecute. Now, what he is not saying, he's also said, I'm not going to give you any guarantees, but, guys, read the tea leaves.
One of the kind of three components of any investigation, violation, enforcement action, incident, or day-changing event, as I've learned that is a new term today, is the following. What did you do to prevent it? What did you do to detect it? And after you found out about it, what did you do to fix it or remediate? If a company self-discloses or self-reports and then comes in with an extremely aggressive and strong remediation plan, that they move to become an industry leader, do you think that's one of the factors that Director Green would consider in the public interest, that he could show a company taking these affirmative, aggressive steps to really become a lead, have a best practices program, or is it simply going to turn on the nature of the violation?
These things are obviously fact specific, but that said, I'll get back to what I just said really, which is if you do a proper self-report, I can't go into all of the sort of the preconditions to that, and it is complicated, but plainly a program to fix it, and I prefer fix to remediate, so much better use of the word, is going to weigh heavily. But it is just one of the components. I mean, I think it's sort of assumed, frankly, that if you are going to do a genuine self-report, will incorporate a genuine program to fix it.
Well, for instance, here in the United States, we see the difference in the penalty phase of companies that work very hard to remediate a program, give the Department of Justice some confidence that they can continue the remediation after the settlement or not. Here in the last week, we had two FCPA enforcement actions, one involving a company called Diebold and the second involving a company called Stryker. In the Diebold action, they paid a fine and penalty and then were required to have a corporate monitor oversee their implementation of a compliance solution for the next 3 years. They signed a deferred prosecution agreement, which is a criminal matter enforced by the Department of Justice, contrasting that with Stryker, which was not even prosecuted criminally. They were prosecuted civilly only by the Securities and Exchange Commission, but they didn't sustain a corporate monitor. So we see differences in the way corporations approach this last step of how do you fix it. And one of the things that I would hope Director Green would take into consideration is just that. If a company really goes the extra mile to not only acknowledge their conduct in the past, but try to fix it going forward, that would be something that he would see in the public interest, not simply as being a good corporate citizen.
Yeah, no, I think he will. Like I say, I think that's in his mind. That's just going to be one of the frankly mandatory components of somebody that in his book has done a genuine self-report. If you do a genuine self-report, but you don't have a fix-it program in there of all the good stuff that you have done, you're not going to get the credit. You're not the leopard has not changed its spots.
I'm a firm believer that there is nothing that has ever been thought of that's new, and except that I've just learned it, the Fix-It program. So I'm going to have to purloin that from you. That is a great term.
The problem with the Fix-It program, Tom, is that you have to make sure it's the Fix-It program, and you don't become Mr. Fix-It.
That is excellent, the Fix-It program. If I can now turn to a little bit different focus of a blog post you put up over the past week. You had an interesting question in from a concerned citizen.
A concerned citizen, yeah.
And the title of the blog post was, "A Purchaser Worries About the Liabilities After Buying a Business with Limited Information Up Front." I'd like to go into this in some detail because you give some very practical advice. But one of the things that has become clear to me is you never have enough time in pre-acquisition due diligence, whether it's on the financial review side, whether it's on the compliance review side. Some countries have rules which limit your ability to look at books and records prior to an acquisition. So with all of that as background, could you go in, for our audience, go into the background of the question and then give the advice that you proposed?
Yeah, and the background was a corporate looking to make an acquisition with a very limited amount of information available for it to review. Perhaps it could be in a data room, or if you're doing a deal in the UK and you're buying in a sort of hostile takeover situation, a publicly issued company, then you are only going to get what's in the public domain. And we all know there's a whole load of information you're not going to get. You're only going to find out pretty much what you bought in more detail the day that you buy it, and frankly, in the weeks and months and years that follow. And so the concern is that, we've all read the Transparency International laundry list of things that you're supposed to do before you buy something, and best practice is that you do a full FCPA, anti-corruption, bribery, whatever you want to call it, review before you do. Trouble is, in my experience, that never happens. You don't get enough time to do it, even if you wanted to do it, and wanting to do it is a big question as well. But you just don't get enough time, so that question of wanting to do it or not is pretty much redundant. So does that mean that from now on there can never be another M&A deal? Well, in the real world, that is obviously rubbish. So M&A must continue to be done and will continue to be done. So what do you do? In the US, there is this opinion. I know you've got your opinion procedure. In the UK, that was unceremoniously yanked from the SFO website a year ago by the not-so-new director, David Green. And so many people were scratching their heads about what to do. I'm pleased to say it didn't stop the M&A machine in the UK from whirring. But it does leave this question. And the answer, my answer to that question is basically, you do the best you can, which means that you get your warranties and your representations, you do what diligence you can before you buy. You know that's not going to be enough. But afterwards, you've got all the time in the world, and you need to embark on a proper diligence program. You need to do that anyway, because you're integrating this new business into your business. We all know the problems that emerge if you don't do that properly. I think there have been plenty of FCPA actions on that, and the same applies, will apply in the UK. M&A is a major reason for law enforcement getting interested, and you should look to sort of put in systems and controls if they don't exist, and look to integrate all of those into your business. If you do all of that and you uncover a problem, and you then self-report that problem, if necessary, and there may be bits around that where, say, for a UK corporate without a US nexus, I can anticipate a scenario where perhaps technically you don't have to do that. But anyway, that is far too granular for this. Let's assume you self-report it, you do the right thing. The short answer is I just don't see that there is a public interest in those circumstances for a UK prosecutor coming after the purchaser. Because it would be lunatic if there was. So that's my sort of answer. That's my answer to the question. I'm pretty confident about that. You asked another question, which was, that's all very practical, Barry. And I suppose, you have to be practical, don't you? Otherwise, as a Howard, a former illustrious co-presenter of yours said, you end up in the idiot box if you come up with unpractical stuff and people don't phone you up anymore. And I'm very keen not to end up in that place. So, but the other part to it is, I think maybe it's sort of my sort of DNA a little bit, because unlike many FCPA bribery practitioners, my background, when I qualified as a lawyer far too many years ago, I did a lot of work as an M&A corporate lawyer, commercial lawyer. So I sort of come at things from a slightly different perspective. Now, that all changed for me. In fact, I've probably spent more years doing this than I ever did as a pure play corporate lawyer. And I qualified, I think, in 1990 something, the early 90s. But I have spent more time doing this. But that means that I'm often asked by corporates. I sort of get what they want. I sort of get what it is they're trying to achieve. and I am a realist and a pragmatist, I think.
Well, that's one of the criticisms that several commentators in the United States have, that there's too much fear-mongering by the what we would call the FCPA commentariat, and I think you certainly take the opposite approach, which is much more practical advice. Barry, we're near the end of our time, and I would like to end with a couple of perhaps shorter questions, or maybe shorter answers would be the right way to phrase it. The first one was, one of the blog posts you put up talked about industry sweeps, so I'd ask you to give a few words about that, and then maybe if you could just give us a little teaser as to what might be coming in terms of blog posts about the Q&A.
Yeah, okay. Yeah, the sector sweeps, there's a bit of a theme. So I think there was something which I posted a few months back about sector sweeps, and certainly the director has said that he is very interested in sector sweeps. That sector sweep story emerged because a journalist from the Financial Times asked a specific question about sector sweeps. His answer was that we're building our intelligence and we definitely want to do it, and if I start, I'm going to get the bribe payers index out from Transparency International. I'm going to start at the top. And I'm going to work my way down. So, frankly, not a bad place to start, not a bad MO. That's what he decided to do. So that's that. On the construction sector, just to round the point out, that was number 1 on the bribe payers index. And if you look at the post beneath that post on my website, you will see the construction sector itself said 50% of that industry said that bribery was prevalent in the industry. So this is not news; they say it themselves. So yeah, that in terms of teasers, dealing with that point, I'm going to. The SFO is just one of the law enforcement people interested in bribery act enforcement. I've got some quite interesting things which I got from the City of London Police, which are the sort of major sort of fraud, anti-bribery enforcement people outside of the SFO. They had something interesting to say on facilitation payments, which is, I will simply say, it's provoked interest from Transparency International, but I won't say any more than that. All I'm going to say is watch this space. Read thebriberyact.com. There's lots up there, more to come.
I was going to say that you write at thebriberyact.com, but I would ask you, if readers wanted to contact you, could you give us your email address?
Yeah, it is. Well, if you go log on to thebriberyact.com and click through Contact Us, you'll see that's easy. But otherwise, it's Barry, B-A-R-R-Y Vitou, V-I-T-O-U, at pinsentmasons.com, where I'm a partner and I head the corporate crime and investigations team.
Well, this was really a great roundup and a lot of good information, and we certainly look forward to hearing the upcoming your upcoming opinions, thoughts, and comments on the rest of the regulatory event. So thank you very much.
Perfect, thanks.